Masechet Shevuot, Daf Lamed Dalid. The daf today is going to be analyzing the baraita that we saw at the end of the previous daf. So let's review that baraita. We'll do it piece by piece. The baraita asks, Minayin shen hakatuv medaber ela b'tibiyat mamon. We're talking about Shevuot ha'edut. That is, if someone comes and says, listen, I have a claim and you know testimony about it, that person owes me money. Can you testify on my behalf? And the witnesses vow and say, we don't know anything about it. We have no testimony for you. And they swear to it, but they're lying. Then they are liable to bring a korban. That is Shevuot ha'edut. This baraita says that this only applies to a claim regarding money. If the witnesses know something about a different type of subject matter, like murder, and they lie and say we don't know anything about it, that's not Shevuot ha'edut. They don't bring a korban for that. Rather, it's only about a claim of money. How do you know that? There are a few answers. The first one is by Rabbi Eliezer, who used an interesting type of gezer hashava from the word or. Just means or, but it happens to be that regarding Shevuot ha'edut, there are many ors, or this, or that, and also Shevuot ha'pikadon. So we're going to compare the two, just like Shevuot ha'pikadon. That's a vow that, yes, you gave me this item, but I don't have it anymore. It was stolen, but really I took it. If I make such a vow, that's called Shevuot ha'pikadon, I also have to bring a korban. And so since that is only about monetary matters, by definition, it's about a deposit. So too, Shevuot ha'edut is only about monetary matters. That's how he learns it. But then we wonder, how about regarding murder? There's a lot of oz in that sentence when it describes murder. And so why not say that Shevuot ha'edut applies also to a case like that, and not only to money? And so we say, no, we're going to apply it to two cases that are more similar in that they both have a vow, Shevuot ha'pikadon and Shevuot ha'edut both regard a vow, whereas a case of murder does not involve a vow. We ask, why not bring in sotah? Because sotah involves a vow. The kohen makes her make a vow. And the final answer is that we're going to use something where there is a vow and there's no kohen involved. And that's what Shevuot ha'edut and Shevuot ha'pikadon have in common, whereas the murder has no vow, and sotah involves a kohen, and these don't. So that was Rabbi Eliezer's final answer. Now let's ask a question about that. Matkif la Rabba bar Ula, o bitu yochichu shehen o'in veyesh mahen shevuah ve'en imahen kohen umedaberim shelo b'tviat mamon. Why don't they bring in the oz in Shevuot bitui? Shevuot bitui is if I say, I'm going to eat tomorrow, or I am not going to eat. And the pasuk there has a lot of oz, says, or if he shall take an oath to clearly express his lips, or to do evil, or to do good, lehara, or lehetiv. So it has the same formulation of o. And there it has the same criteria that it involves a vow, and there's no kohen involved. And a vow of Shevuot bitui applies not only in monetary cases, like I'm going to give that person $100, it applies even if I say I'm not going to eat. And therefore, why not learn from Shevuot ha'edut compared to Shevuot bitui and learn that Shevuot ha'edut would also apply to non-monetary cases? That's the challenge that of Rabba bar Ula. So we answer, it makes more sense to compare it to Shevuot ha'pikadon because they both share a word, teheta. Wait, why not learn it from Shevuot bitui? Because the korban for both of them is a korban hatat, whereas the korban that you're liable for Shevuot ha'pikadon is an asham. So you should learn, so Shevuot bitui is more similar, and then we will include non-monetary cases in Shevuot ha'edut. אלא מסתברם פיקדון הבעלי למלף, שכן חטא במזיד, טבעה וחפרה ועברה. Rather, it makes more sense to compare Shevuot ha'edut to Shevuot ha'pikadon because it has the following things in common. Number one, the word chet, that's what we just said over here, teheta. Second, bemezid. Shevuot ha'edut, as we saw, applies when someone made a vow, bemezid. He knew that he knew testimony, he remembers the testimony, and still makes a vow, knowing full well that it's not allowed and that he is lying. That's when he brings a korban. If he forgot about the edut, then he actually does not bring a korban. It's an unusual thing. And that is true not only for Shevuot HaEdut, it's also true for Shevuot HaPikadon, at least according to the majority opinion. The Mishnah in the next Perek, which is coming soon, is going to, in fact, tell us that Shevuot HaPikadon, one is liable when one violates it be'mezid. It's not the opinion of everyone, and we're going to see today a minority opinion that disagrees. But right now we're following this majority opinion that both of them are apply be'mezid. And also, they involve a claimant and someone denying the claim. Someone has to come and says, you know edut, swear to me that you have edut, or you have my item, right? Swear to me that that it was stolen, and he denies it, and also they're about the past. So all these things are true about Shevuot HaEdut and Shevuot HaPikadon, but they're not true about Shevuot Bitui, which is about the future, and there's no claimant, and that's b'shogeg, and doesn't have the word tachati. So therefore it makes more sense to compare it to Pikadon, and therefore it's only regarding monetary cases. But then we say maybe not, adrabah, maybe tu hava lemelaf sheken hatat sheyarda lechomesh hanach nefishan. So why not compare Shevuot HaEdut to Shevuot HaBitui? Because they also have a number of things in common. Number one, korban chatat that they both bring. And the type of korban chatat, sheyarda, is korban oleh v'yored. And in these two, you do not pay an extra chomesh, unlike Shevuot HaPikadon, where you have to add another fifth to the payment amount. So this has three things in common. So why not compare it to this? And the answer is Hanach Nefishan. The first list of Shevuot HaPikadon there's more items that are similar. 1, 2, 3, 4, or 4 or 5, depending on how you count Teva and Kafre. So maybe 5 things, and this only has 3 things, and that's why in the end we compare Shevuot HaEdut to Shevuot HaPikadon, and therefore Shevuot HaEdut applies only to monetary cases. Rabbi Akiva Omer, Rabbi Yesham le'achat me'ele, yesh me'ele shu chayav, yesh me'ele shu patur. Ha'kesat b'mamon chayav, tebov davar acher patur. Back to that baraita, the second opinion there is that of Rabbi Akiva. He says, how do I know that Shevuot HaEdut is only for monetary claims? Because it says if someone will be guilty regarding one of these, means that there are many cases, but one is liable to only one subcategory of all the cases. So some of them are liable, for some of them one is not liable. Which one is which? If the claim is regarding monetary things and someone says, hey, you guys come and testify regarding this monetary thing that person owes me money, and they deny it, then they are liable. But if he asks them to testify about a different matter that's not monetary, that's patur. That's what we learned from one of these things, one category among all the categories. We ask Rabbi Akiva, epuchana, we could say the other way around. Maybe if it's a monetary case, that's the one that's patur. And non-monetary cases, that's when they are liable for lying. How do you know which one is which? Rabbi Akiva a'o'in Rabbi Eliezer samich. And the answer is that Rabbi Akiva, who comes right after Rabbi Eliezer, is actually not disagreeing with Rabbi Eliezer, but adding on to it. He agrees with Rabbi Eliezer's derivation from the one that we just saw, and relying on that, he adds another added derivation of le'achat me'ele, one of these. Now, by adding another derivation, that suggests that he's also further limiting cases of liability. So we ask, my benayhu ben Rabbi Eliezer ben Rabbi Akiva, what would be a case where they would disagree? Ika benayhu mashbi'a ede karka, Rabbi Eliezer chayvin, Rabbi Akiva peturin. The difference between them would be if someone asked the witnesses to testify about a case regarding land. Now, land is a monetary matter, it's worth money, but is it the same or not? So Rabbi Eliezer would say, yes, it's included within a monetary thing. You tell the witnesses, testify that person has to give me this certain piece of land that he owes me. And they lie, they're liable. According to Rabbi Akiva, who said, me'ele, achat me'ele, so that's further limiting, and that excludes land cases. Only if it's movable items would one be liable to Shevuot HaEdut. Rabbi Yochanan damar ata mashbi'a ede karka afilu Rabbi Eliezer peturin, hacha mai ika ben Rabbi Eliezer Rabbi Akiva. But regarding that matter, Rabbi Yochanan said that if someone asks witnesses to testify about a matter of land, Even Rabbi Eliezer says they're not liable. In that case, Rabbi Eliezer and Rabbi Akiva agree that witnesses are not liable if they had no testimony about land. So according to Rabbi Yochanan, what's the difference between Rabbi Eliezer and Rabbi Akiva? And the answer is, Ika banayhu ade kenas. The difference is, if they are asked to testify about a fine, not about damages or money that's owed because he took something, a loan or damages, but rather as a fine. And that's where Rabbi Eliezer says a fine is also a monetary matter, and therefore they are liable if they withhold testimony. Whereas Rabbi Akiva, who said achat me'ele, is further limiting it, and therefore says no, fines are not included in liability. רבי יוסי הגלילי אומר, והוא עד או ראה או ידע, בעדות המתקיימת בראייה, בלא ידיעה, ובידיעה, בלא ראייה, הכתוב מדבר. Rabbi Yosef HaGalilee had a different derivation, and it's right over here. Since the pasuk regarding Shevuot HaEdut says, and he was a witness, and either he saw or he knew. That suggests that there are cases where he sees but doesn't know, and knows but doesn't see. And the Baraita that we saw on the previous daf went ahead and gave examples. What does it mean if you see but don't know? That means if you see, maneh maniti lecha bifnei ploni uploni. Someone says, I counted out a certain amount of money before so-and-so. And the other person says, yeah, let witnesses come and testify that I counted out that money, and then I'll believe your claim, even though they don't know what the claim is about. And witnesses, if they would come, and they could testify, yeah, we saw that this person counted out $100 to that person and gave it to him. We don't know what it was for. We don't know if it was a gift, if it was a repayment, it was a loan. But we saw him count it out, and the plaintiffs agree that if the witnesses know that, then they will accept it. So this is a case where the witnesses saw something, although they don't know the content of what they saw. That's included in Shevuot HaEdut. And the other way around, Yedi'ah belo ri'iyah, they know something, although they didn't see it. That's if someone makes an admission and says, this person, maneh hodet ali, you admitted, the plaintiff says to the defendant, you admitted to me in front of these two witnesses that you owe me 100. Now the witnesses don't know, did not see the actual transaction, the original transaction of where there was a loan or whatever happened that would have required, but they know based on the admission, so they can come and testify. And if the other person would say, yes, I would agree to that, so they can testify about that admission, and that would also be sufficient to extract money. Therefore, if they deny it, that will be sufficient to be Shevuot HaEdut and make them liable to bring a korban. And Rabbi Yosef says proof from all this is that you can only have such cases regarding monetary matters where there is knowledge but not seeing, or there is seeing without knowledge. You can't have that in other cases like in murder, and therefore all Shevuot HaEdut is only in matters of monetary cases. Now we're going to question that part of the Baraita. Amar le Papa Abaye. Lema Rabbi Yosef let Rabbi Acha. It seems, Papa tells Abaye, it seems that Rabbi Yosef would not agree with the following halacha of Rabbi Acha. The Tanya. Rabbi Acha omer, Gamal ha'ocher ben ha'gemalim v'nimsa gamal harug b'sido b'yadua shezeh harago. Di'it le de Rabbi Acha b'dinei nefashot nami mashkach adai k'de Rabbi Shimon ben Shatach. Rabbi Acha's halacha in a Braita is that if a camel is in heat, right, and so when camels are reproductive in that season, then they act very, very wild. And if you find a gamal ha'oched, that's what it's called, and there's other camels around, it tends to fight with the other animals for dominance, and it can be so violent that it can kill another. So you find many camels owned by different people, and then there's a dead camel next to the camel that was in heat, that was rampaging all around. You can assume that it was the animal ha'oched, the gamal ha'oched. That camel is the one that killed the one that's dead, even though no one saw it specifically kick that one. But since that's the one that was acting in a wild way, it killed the other one, and the owner of that gamal is going to be responsible to pay. In other words, Rabbi Acha holds someone responsible. This is a financial case, where there's only a presumption. There's no witnesses specifically to that. Circumstantial evidence. There's no other. All the other camels were tame. This camel was wild, and it's right next to him. It must be that's the one that killed him. So it must be Rabbi Yosei Gali does not agree with Rabbi Acha. Now, in this case, Rabbi Acha, it's a monetary case, so there's no problem here. But there's a consequence. If you accept circumstantial evidence here, then you would also accept circumstantial evidence in a similar case, but one that is involving murder. So if you agree with Biacha, then regarding murder, you could also find a case, and that's the case that happened to Rabbi Shimon ben Shatach, de Tanya. אמר רבי שמעון בן שטח, אראה בנחמה אם לא ראיתי אחד שרס אחר חברו לחורבה. ורסתי אחריו ומצאתי סייף בידו, ודם מטפטף והרוג מפרפר. אמרתי לו, רשע, מי הרגו לזה? או אני או אתה. He says, may I not see the consolation of Jerusalem if I did not see. So he's making a vow. I saw someone run after someone else, and they went into a ruin, an empty house, and I ran after them to see what was going on. And as soon as I got in, I saw that the guy who was pursuing had a sword in his hand, and the sword was dripping blood. And I saw the other guy, he was slain, and he was still moving, still convulsing, meaning he was just killed. And now I saw the other guy walking out with a sword and a bloody sword. So it seems obvious that that's the guy that killed him. There's nobody else in the building. There's nobody else around. And this person was just murdered. But it's circumstantial evidence. There, he didn't specifically see the guy thrust the sword into the murder victim. So Rabbi Shimon ben Shatach says, you evildoer, who killed this person? It's either me or you. There's nobody else around here. And obviously, it was not Rabbi Shimon ben Shatach. But what can I do? Your blood, your guilt is not given over to me, because the Torah says, based on 2 or 3 witnesses, one can bring a criminal to justice. And first of all, only one person, and I didn't actually see you kill this person. So we can't bring you to a bet din that you should get capital punishment. Ela makom yipara mimecha. Rather, I pray that Hashem will find you punishment. Amru lo zazu misham ad sheneshacho nachash umet. And they said that they didn't leave that place until a snake came and bit that murderer, and he died. So he got what was coming to him, although they could not do it based on circumstantial evidence. Now, if you would agree with Rabbi Acha that you can find someone guilty based on circumstantial evidence, because that's what happens with the camel. This is the only camel that could have done it, and the murdered camel is right next to it. Then you should allow circumstantial evidence also, and not only in a monetary case, but also in a capital case. And if you can do that, that is an example of knowing without seeing, right? Rabbi Shimon ben Shatach, and in the case of Rabbi Acha, the people that were there, Rabbi Shimon ben Shatach himself, he says, I know you're the murderer. I didn't see it, but I know you're the murderer. And Rabbi Acha also in that case. Now, according to Rabbi Acha, even if you know but didn't see, you can assume that this person is guilty and make him pay. So Rabbi Acha would say that so too in the case of murder, circumstantial evidence could be counted. The fact that you know, even though you can't see. What do we see from here? This will refute Rabbi Yosei Galili's argument, because Rabbi Yosei Galili said that the Shevuot Edut has to be monetary cases, because only in monetary cases can you find a case of seeing without knowing and knowing without seeing. But now we just showed that if you would accept Rabbi Acha, then you could have a murder case also where you have knowing without seeing. And then that would be included also because vu ed ora'a o yada. So you can have such a case of yedi'ah belo re'iyah. So therefore it must be that Rabbi Yosei Galili does not agree with Rabbi Acha. So that seems to be a conclusion that makes sense. But we don't want to limit him in that way. So we answer, afilu tema itle de Rabbi Acha. We can even say Rabbi Yosegli would agree with Rabbi Acha. And yes, indeed, we could come up with a scenario of knowing without seeing in the case of murder. That's true, but you need both ways. Seeing without knowing, that you only have in a monetary case and not in a murder case. And you couldn't have it in a murder case because, what would that mean? You saw someone kill someone else, but you don't know the exact circumstances. It's like seeing, I saw this person gives $100 to that person, but I don't know why they gave it. Well then, what do you know about what happened? And in the case of monetary case, okay, it could be, well, I know they accepted, the both parties accepted. If you have testimony that I gave money to that person, then I'll agree to you. But in the murder case, how could you have that? Mila ba'eh Meda im goy harag or Yisrael harag, im adam terefa harag or shalem harag. In order to give capital punishment, you only get capital punishment if you kill a healthy Jew. But if it's a non-Jew, although it's not allowed, it's not the same punishment, capital punishment. And terefa, if it's someone who would die anyway within 12 months because they have a disease, then also someone who murders them, again, not allowed, but doesn't get capital punishment. And so, just because you saw A kill B, but you don't know who the victim is, what kind of person he is, and what his health status is. And you would never be able to give someone capital punishment if you had seeing without knowledge. And that's why Rabbi Yosef Galili says that we need both in order for it to be included under Shevuot Adut, and only regarding monetary matters, so you have both. In other matters like murder, you have an example one way, but not the other. Shema mina kasaba Rabbi Yosef Galili mashpia adei kenas patur. And now the Gemara adds that we can derive from the logic that we just presented that according to Rabbi Yosef Galili, if the witnesses say we don't know anything about a case of a fine, then they are not liable, although they are lying. We saw this is a machloket, whether a fine is included in this category of mammon, for which one is liable to Shevuot Ha'edut. It is a financial matter, but it's not about loan or damages, it's a fine. And so is that included or not? According to Rabbi Yosef Galili, must be it's not. Why? Because because if you say that the witnesses would be liable, then we need to find both cases, yedi'ah belo riyah and riyah belo yedi'ah. So we could find a case of a fine where the witnesses have knowledge, although they did not actually see the crime itself that triggered the fine. For example, they saw a man and a betula go into seclusion. And then they come out, and now she is not a betula anymore. Something happened in there, and assuming that's a rape or something, that would cause him to have to pay a fine. So they didn't actually see the act, but circumstantial evidence, there's nobody else around, must be that he did it. So you can have a case of yedi'ah belo re'iyah that triggers a fine. But the other way around, re'iyah belo yedi'ah, mi la ba'e meda, goya ba'al, bat Yisrael ba'al, betula ba'al, be'ula ba'al. If they saw an act, they saw this man and this woman do an act, but they don't have knowledge of the details, so is that sufficient? Would they to testify that the person has to pay a fine? Wouldn't they need to know whether the woman was not Jewish or not Jewish, whether she was a betula or a be'ula? That would be essential information, and without that, they would not be able to testify. And therefore, since you don't have both ways, there's no case of a fine that where you have re'iyah belo yedi'ah, it must be Rabbi Yosef Galili would exclude that case of liability for Shevuot Ha'edut. Yatev Rav Hamnuna kamed Rav Yehuda, ve'yatev Rav Yehuda v'ka mi'ba'yaleh. One time Rav Hamnuna was a student and he was sitting in front of Rav Yehuda, the teacher. And Rav Yehuda, the teacher, was asked a question. Maneh miniticha bifnei peloni ufiloni. Someone comes and makes a claim and says, I counted out 100 dinar to you and gave it to you in front of these two witnesses, right? And therefore you have to give it back to me. There were witnesses that saw outside, they saw this happen, they saw a person count out, but they don't know the circumstances. So then when he says, and you have to pay me back, Well, we don't know if he gave it as a loan, or if he gave it as a gift, or if he gave it to pay damages. Who knows what it was for? So the teacher was wondering what to do in such a case. Amar le Rav Hamnuna, the student says, I know. What is the other guy? What's the counterclaim? When the other person says, when one person says, I gave you $100, what does the other person say? If the defendant says, this never happened, I never got $100 from you at all, you never counted it out, well, there's witnesses that say that's not true. And therefore we say, you can assume that the defendant is a liar. So he will have the presumptive status of a liar, and we won't believe him, and that's it, he'll have to pay. But if he says, indeed, yes, I did, you did give me money, but that was money that belonged to me, I lent it to you, you were paying me back, I don't owe you money now. And so the fact that witnesses came doesn't add anything, because the defendant agreed with what the witnesses are saying. The witnesses said, yeah, we saw him give you $100. And the guy agreed, yes, you gave me $100. But the circumstances were such that was already mine that you were paying me. And therefore I don't have to pay you back. And so this was such a brilliant answer that the teacher said, you are Hamnuna, come and enter into the study hall, right? I'm elevating you, I'm giving you a promotion. This was a very good answer, because it's very interesting, because the outcome depends not just on what the plaintiff claims and what the witnesses say, but it also depends on how the defendant answers. So that was a very good answer. Similar case now. A claimant goes to a defendant and says, I counted out 100 dinar to you and next to this pillar. And the defendant said, I never passed by that pillar. I was never there, so it couldn't have happened. You never paid me. Now, two witnesses came and said, we saw one time this defendant, he urinated next to that column, next to that pillar. Since he was there, first he said, I was never at that pillar. Two witnesses come and said, you were at that pillar. Now, the witnesses don't say he got money there, but he did say he was there to take care of his personal needs. So that means that when he said, I was never there, was not true. And therefore, we could assume that he is a liar, and he will not be believed. We will believe the plaintiff. Matkif la Rav Nachman. Haidina parsahu. Rav Nachman said that doesn't make sense. This is Persian justice. They're making fun of Persian courts. Persian courts didn't follow exact logic. They just assumed things, and this makes no sense. Look into it further. Mi kamar me'olam bezek kamar le. When the defendant says, I was never, Allah avarti, I did not pass that column, he didn't say, I never went to the column. Yeah, it could very well be he went there every day and urinated on that pillar. That doesn't matter. The point is, I never went to that column regarding this matter and gotten this money from you. For that reason, I never went to that column. And therefore, you can't hold him guilty and assume he's a liar, because we don't know. The witnesses only saw him urinate there. That's not such a significant act. But if he's saying, I never went to that column and had you pay me. Therefore, we cannot say that the plaintiff is right and the defendant is a liar. The defendant could be right, and the fact that the witnesses say he urinated there one time does not help the plaintiff's case. Another version of this case. Starts off the same. Someone says, I paid you next to this column. But here's the difference. Here the defendant says, I haven't passed by that column ever. I was never even near that column. Impossible that you paid me next to that column. Now the witnesses came and said, yeah, we saw you one time, you urinated on that column. In that case, Rav Nachman said, oh, this person must be a liar. Here's Rav Nachman saying who was the judge. He's lying because he said he never went there, but the witnesses say he went there at least once. If he's lying about that, then probably he's lying. We cannot trust him about receiving that money. And here it's Rava that rejects Rav Nachman. Amar le Rava, Rav Nachman, kol milta de la ramya ale di inish. Abid la ve'la vadate, very important principle. Anything that you cannot expect a person to remember, then we do not expect it. Then it's not on his mind. Any matter that is not incumbent upon a person to remember, he performs it and is not on his mind. In other words, urinating in front of a column, that's not a significant thing. People don't remember everywhere that they go number one. It's not significant that he went to that column. It's not expected that he would remember it. So it's out of his mind. So when he said, I never went to that column ever, so that we can say is true. We can believe him. And the fact that when this is said he urinated there once is insignificant. We could still believe him when he says, I never went there ever, and because I never went there for a significant purpose. That's what he means. I would remember if we met there one time and you gave me 100 dinar. That would be memorable that I got 100 dinar from there. That you expect him to remember. So if he denies something that's memorable, then we say, oh, you're a liar. You're not saying anything. But if he doesn't remember something that's not particularly memorable, then we don't hold that against him. And therefore, Rava disagrees with Rav Nachman's ruling and says that the fact that he denied ever being there le'olam is not significant. We have to believe him even though he was there one time to urinate, but that's not a memorable thing. Rabbi Shimon Omer, chayev kan v'chayev bepikadon. We next analyze the proof of Rabbi Shimon that Shevuot Ta'edut applies only to monetary cases. And he brought actually a three-step proof. The first one, he said that we're comparing Shevuot Ta'edut to Shevuot HaPikadon. And just like regarding Shevuot HaPikadon, it's only monetary matters, so to Shevuot Ta'edut is only monetary matters. So that's just a general comparison, a kind of memasinu. But then he adds to that a kal vachomer. And the kal vachomer is that Shevuot HaPikadon applies to men and women, people that are valid to be witnesses, kosher witnesses and non-kosher witnesses, and so on and so forth. It applies to a lot more cases, and yet Shevuot HaPikadon, even though it applies to all those people, is limited to monetary matters. Then Shevuot Ta'edut, which applies only to men and only to valid witnesses, and is much more limited, certainly will be more limited in that it will apply only to monetary cases. That's a kal vachomer, it makes sense. But then Rabbi Shimon rejects that very kal vachomer because it can be refuted. So this is the refutation of the kal vachomer. We're going to come back to this again and again. So let's read this carefully. Actually, Shevuot HaPikadon itself has a limitation, and maybe the limitation on mammon and pikadon is because of the following two limitations. Number one, in pikadon, we don't say that someone who is administered an oath is like the one who takes the oath. It applies only to someone who makes the oath themselves, but not if someone else administers an oath and says, oh, you do agree to this. Also, Shevuot HaPikadon does not equate mezid and shogeg. It only applies to shogeg, does not apply to mezid, at least according to Rabbi Shimon, although this is a minority opinion, but that's what Rabbi Shimon thinks. So that you cannot compare that to Shevuot Ta'edut, where that does apply to someone to whom an oath is administered, just like if he said it himself, and it applies to someone who makes the vow b'mezid also. So therefore, since Shevuot Ta'edut is more expansive in these two ways, maybe it should be more expansive in being applied also to non-monetary cases, and therefore this kal vachomer that Rabbi Shimon brought is refuted. And so Rabbi Shimon says, oh, you know what? I'm going to use a kal vachomer, techeta, that is said regarding Shevuot Ta'edut and regarding Shevuot HaPikadon. Okay, that was what he said in the end. Now, we're going to ask about that. Mechachu ala b'ma'arava maichucha. When in the West they heard about what Rabbi Shimon said, they laughed at it. Now, what did they laugh at? What part of what Rabbi Shimon said did they laugh at? Dekatane. Malapikadon sheken lo asabo mushpa kenishpa mezid keshogeg. Because it says in the refutation of the kal vachomer that you can't bring a proof from pikadon because a pikadon is actually more limited in that it does not apply to someone who has an oath administered to him and does not apply to mezid. So this is the part that they had a problem with in the West, in Eretz Yisrael. Now, according to Rabbi Shimon, how does he know that if someone made a vow on his own, a Shevuot Ta'edut, How does he know that that would be prohibited? The Torah, when it comes to Shevuot Edut, only talks about someone else administering an oath to him, but doesn't talk about someone making Shevuot Edut on his own. But certainly that would be prohibited. So maybe he learns it from a Gezer HaShavah, Degamar Pikadon. So does he learn it from Pikadon? Pikadon name mushba mepi acharim nigmar me'edut. If you're going to learn it one way, then you can use the same Gezer HaShavah in the other direction, and you'll be able to learn that Pikadon applies also when an oath is administered, and then the law would be the same. So if you're going to learn one way, you learn it the other way, and then the law would be the same, and there would be no refutation of this part of the Kal Vachomer. So maybe that's what they left at. But we reject this. What would be there to laugh at? Dilma Rabbi Shimon bekal vachomer maiti la mepi acherim chaya mepi asmo lo kol sheken. Maybe Rabbi Shimon learned that an individual who makes a vow himself for Shevuot HaEdut is liable. He doesn't learn that from Shevuot HaPikadon Gezer HaShavah, but rather a Kal Vachomer from within Shevuot HaEdut itself. If Shevuot HaEdut, one is liable if someone else administers the oath, and that's what the Torah says, then all the more so if you make it oneself. That's a Kal Vachomer within itself. So there's no, we're not deriving this from a Gezer HaShavah, and therefore there will be no reason to make fun of that part of what Rabbi Shimon said. So we need another explanation. Look at all this all this commentary on why did they laugh. Someone in Israel laughed, and we have to try to figure out what did he laugh at. Rather, maybe they were laughing at the fact that in the refutation, Rabbi Shimon said that Shevuot HaPikadon does not apply to mezid. Dekatane malapikadon sheken lo asa bo mushba kenishba mezid keshogeg, because it says in his refutation how you can't compare pikadon where someone who's administered an oath is not the same as someone who makes an oath, and a mezid is not like a shogeg. So here Rabbi Shimon is assuming that mezid in Shevuot HaPikadon is not liable. Mikedi mezid gabe edut minale. Now, how do you know regarding Shevuot HaEdut that someone who lies on purpose is liable, which is unusual? Usually korban chatat is for not liable. Oh, because in Shevuot HaEdut it doesn't say the word, he forgot. That means he knew. He knew very well that he had testimony and he lied anyway. It doesn't say v'nei alam. In the context there are other laws in that context say v'nei alam. This one doesn't. But let's look at Shevuot HaPikadon. Shevuot HaPikadon also doesn't say the word v'nei alam. And therefore, why doesn't Rabbi Shimon say that Shevuot HaPikadon also applies in mezid? Because it doesn't say the word ne'elam. And maybe that's what they laughed at. No, why would you laugh at that? There's an easy answer. Dilma mezid delav keshogeg b'pikadon me'me'ila Rabbi Shimon gamarla. Maybe Rabbi Shimon learns that mezid is not like shogeg regarding Shevuot HaPikadon, that mezid, one would not be liable to a korban if you did it on purpose, which is the usual thing, that you generally, most korbanot are korban asham, korban hatat mostly, are for shogeg. And so maybe we can learn that Pikadon, Shevuot HaPikadon, is not liable b'mezid from me'ilah. And that's where he will learn it from. So even though it doesn't say the word ne'ilam, but that's not so significant, the fact that we are going to make a comparison, a Gezer HaShavah, in fact, between Shevuot HaPikadon and me'ilah, stealing from the Bet HaMikdash, which is also bishogeg, and that's where he learns it from. So there's no reason to laugh at him. So now we follow up and say maybe that is precisely what they laughed about in Israel. Why did you compare Shevuot HaPikadon to me'ilah? Why not compare it to Shevuot HaEdut? And that, if you do that, then you can learn that in Shevuot HaPikadon, one is liable for mezid, just like in Shevuot HaEdut, instead of comparing it to me'ilah. You can make a Gezer HaShavah both ways. And the answer is, it makes more sense to compare Shevuot HaPikadon to me'ilah, because the word me'ilah, which means to misuse, is applied in both. Both, if you take something that's consecrated and you get personal benefit from it, that's me'ilah. And if you take something that belongs to someone else and they gave it to you as a deposit and you use it for your own benefit, which you're not allowed to, and the pasuk also uses the word me'ilah there. So it makes sense to compare those two and thereby prove that Shevuot HaPikadon, one is not liable in mezid. Actually, you can have a gezer hashava the other way. Shevuot HaPikadon and edut both have the word techeta. So why not learn it that way? And therefore, we would say, just like Shevuot edut, one is liable when one makes a vow b'mezid. So too, Shevuot HaPikadon would be liable when one makes a false vow b'mezid. Mistabra me'ilah havala le'melav. Sheken me'ilah bakol nehene bekavua chomesh ve'asham. Well, it makes more sense to compare Shevuot HaPikadon to me'ilah because, look, they have all these things in common. Number one, the word me'ilah that says in both. Number two, it applies to everybody, not only people that are valid to be witnesses, even people that cannot be witnesses. This applies, Shevuot HaPikadon and me'ilah, man or woman, a gambler, anyone can violate this law. Third, they have in common is that the person gets personal benefit from something that doesn't belong to them, and that they bring a korban, a regular korban, not a sliding scale korban, and they have to pay a fifth in addition to what they stole, and the korban that they have to bring is a korban asham, not a korban hatat. So that's 6 similarities. Chet, Hedyot, Bishmu'ah, Tab'eh, Vechafre, Ve'o'in. Wait, you should compare Shevuot HaPikadon, Shevuot HaEdut, because it also has many similarities. Here they are. Chet, the word techeta that appears in both, that's one. Hedyot, that it applies to non-consecrated things, unlike me'ilah. They both have a Shevuot, Shevuot HaEdut, Shevuot HaPikadon. There's a claimant and a denial in both of these. Someone says, hey, you have my item, or you know testimony about me, and they deny it. And you also have the Gezer HaShavah that we started with the O'in. So this, well, if you count Teva and Kafret together as one, then that would be 5. So we see that the me'ilah is more, that has 6 similarities, this has only 5 similarities, and therefore it makes more sense to compare Shevuot HaPikadon to me'ilah, and thereby there is no liability of a korban for mezid. So there's no reason to make fun of Bishimon for that. Ella ma'chucha. So we still have the question, what were they making fun of in Eretz Yisrael about Rabbi Shimon's argument? So in a papa and Rav Huna, the son of Rav Yoshua, came from the study hall. They said the following answer: Hainu chucha mikedi Rabbi Shimon gezerah shavak gamir lama le de parich malapikadon sheken lo asabo mushpa kanishpa mezid keshogeg. If in the end Rabbi Shimon has a gezerah shava of techeta, because in the end he relies on a gezerah shava between Shevuot HaEdut and Shevuot HaPikadon, to say that the laws are the same, they apply only to monetary, this applies only to monetary, so Shevuot HaEdut only applies to monetary cases. If they have a gezerah shava, then why did they refute the Kal Vachomer and say that Shevuot HaPikadon is not mezid? Say it's mezid also, because you have a gezerah shava between them. And why did you say that it applies only? It does not apply if someone administers the oath. Say it applies to when someone administers the oath, because you could learn from Shevuot HaEdut to Shevuot HaPikadon. So why did you refute the Kal Vachomer if you have a gezerah shava that makes the two laws actually the same? The answer is umay chucha. Now that would not be a reason to make fun. Dilma ki parich mikame de tekum le gezerah shava. Batar de kama le gezerah shava la parich. Now maybe when Rabbi Shimon rejected the Kal Vachomer, that was before he established the gezerah shava. But after he established the gezerah shava, indeed, then we could go back and the Kal Vachomer would work. Now it doesn't help that much because you already have a gezerah shava. It would have an additional proof, but actually without the gezerah shava, the Kal Vachomer wouldn't work. But indeed, the rejection of the Kal Vachomer would be undone once we have the gezerah shava. Velo v'amar lehu Rava bar Itai l'Rabbanan man tena Shevuot HaPikadon lo nitan zona l'chapara Rabbi Shimon hi. Wait a second, is that true that Rabbi Shimon, once he established the gezerah shava, he thought that all the laws of Shevuot HaEdut apply also to Shevuot HaPikadon, but Rava Bar Itai asked the rabbis, who is the author of the following statement, who says, Shevuot HaPikadon, if you do it on purpose, there's no atonement. You don't bring a korban. And they answered, it is Rabbi Shimon. So you see that Rabbi Shimon does not equate Shevuot HaPikadon, where one does not bring a korban for mezid. It does not equate that to Shevuot HaEdut. So even after the Gezer HaShavah, he would still have this point of refutation against the Kal Vachomer. Dilma mezid keshogeg parich degamar la me'ila dehanach nefishin aval mushpa kenishpa la parich. So the Gemara answers, maybe indeed when it comes to mezid being like shogeg, there Rabbi Shimon's refutation of the Kal Vachomer indeed does stand. Because we just saw here that Rabbi Shimon thinks that Shevuot HaPikadon, mezid, is not liable. And so in that sense, according to Rabbi Shimon, Shevuot HaPikadon is more limited. And because more limited in that it does not apply to mezid, so too maybe it's more limited in that it applies only to mammon, and you cannot learn from there a Kal Vachomer to Shevuot HaEdut. And so maybe indeed that refutation will stand. Why? And why would Rabbi Shimon not learn from Shevuot HaEdut? Because he learns it from Me'ilah, because the comparisons to Me'ilah are more. So indeed, Rabbi Shimon, even after the Gezer HaShavah, between Shevuot HaEdut and Shevuot HaPikadon, will not learn the law of Mezid to Shevuot HaPikadon, because Shevuot HaPikadon is more similar to Me'ilah. But when it comes to the other matter of Mushpa Kenishpa, there he would rescind his refutation of the Kal Vachomer, although he at first said that Shevuot HaPikadon only applies to the person who makes the vow himself and not to someone who is mushba. After you make a gezerah between Shevuot HaEdut and Shevuot HaPikadon, then you can apply one to the other and say, just like Shevuot HaEdut applies when someone administers, they also too, Shevuot HaPikadon applies when someone administers oath, and this is the same in that sense. One would not use that point as the refutation. One would only refute the Kal Vachomer from the mezid and shogeg. V'tadad edut v'tigamar la mipikadon mezid delav keshogeg ma pikadon shogeg in mezid la af edut shogeg in mezid la ki echid dialif pikadon me'ila. And now we ask, why don't you come and bring Shevuot HaEdut and learn that from Shevuot HaPikadon? That, just like regarding Shevuot HaPikadon, a mezid is not like shogeg. And mezid, you do not bring a korban, and we'll make the comparison as such. Ma pikadon shogeg in, just like regarding Shevuot HaPikadon, only if you do it by mistake, then you have to bring korban, but not if on purpose. So to Shevuot HaEdut, only if you make a vow by mistake when you forgot that you know testimony, but not if you did it on purpose. And you can learn it just like you learn from Me'ilah. Just like we learn from Me'ilah to Pikadon, we will learn from Pikadon to Shevuot HaEdut. And so learn all the way the other way around, that Shevuot HaEdut, one is not liable for Mezid. And the answer is lahachi ketabar achamana le'edut gabe Shevuot bitur v'gabe tumat mikdash v'kadashav debechulan ne'emar behem v'ne'alam v'chan lo ne'emar behem v'ne'alam dechayav le'mezid keshogeg. No, you can't learn that because the proof of the lack of a ne'alam is very strong when it comes to Shevuot HaEdut because of the context. This is why the merciful one, Hashem, wrote the topic of Shevuot HaEdut in the middle of the other laws of Shevuot Bitui and Tumat Mikdash V'Kadashav, because in all those cases it says V'ne'alam, that he didn't realize he was Tameh, he didn't realize that this Shevuot Bitui was false, it was Bishogeg. He said, I'm not going to eat, he forgot about it, and then he ate, or he forgot that he was tameh, and he entered into the mikdash. In those it says, v'ne'alam, and the only one in that whole context that it doesn't say ne'alam is regarding Shevuot HaEdut. So you see that absence is glaring. So because of that glaring absence, it's clear that Shevuot HaEdut applies to mezid. Because the word v'ne'alam does not appear there. So that's a very strong proof, and that proof will be stronger than learning from a Gezer HaShavah from Me'ilah to Shevuot HaPikadon, and then from Shevuot HaPikadon to Shevuot HaEdut. That proof is less clear, and therefore we conclude that, according to the Rabbi Shimon at least, Shevuot ha'edut, in fact, applies to mezid, but Shevuot ha'pikadon does not apply to mezid. Baruch Adonai le'olam, amen ve'amen.